All right, what is Chapter 19? Formation of sales and lease contracts. How do you form them? What are the terms that you negotiate? Okay. Remember, what are we talking about? Sales and lease contracts only deal with goods, right? That is the only subject matter of this contract. That's it. That's all you can do under UCC Article 2 is either agree to buy or sell goods or lease goods. That's all you can do. Well, you know, you could fill in all the gaps in the world, but you cannot fill in the gap of the subject matter of a contract. What is it that you're selling? What is it that you're leasing? So at the first stage, when you're forming a contract, it is important to identify the goods. Distinguish what it is that the seller or the lessor is either going to be selling or leasing to the other side. And there's no, I mean, you know, you could talk in archaic terms, but there's really no mystery to this. I am buying, you know, if goods are sort of fungible, you're selling me software, you're selling me that's readily available, you're selling me dresses, you're selling me handbags. Yeah, all right, we know what they are. You're going to get them as a seller from somewhere, right? But if goods are going to be specially made, manufactured, then it's a different story, because right now you don't have the software, right? You don't have my custom-made software. What you're going to do is pull the resources together, pull the parts that it will take in order to make that software, right? So it's important to first understand what are the goods that we are talking about, okay? Oh, and by the way, as I sort of already hinted at, there are goods that may not be in existence, right? There are future goods because they don't exist today. Custom-made goods are one thing. The book also gives the example of, you know, I don't know, cattle farmers or something like that. If I'm going to buy livestock, right? I am buying livestock that hasn't even been born yet, right? This is a future contract. You know, nature will take its course, and there will be, you know, calves that are born and so on and so forth. So again, we need to know what it is that the seller is selling and what it is that the buyer is buying. All right, very, very important slide. You just may want to pass by this slide, but I think it is very important to spend a couple of minutes understanding title and ownership. And really the point of chapter 19 and 20 is all about, if you go to the title of the slide, passage of title. Passage of title. Every time you see title, just think ownership, please. I mean, I know this is what the UCC uses, title, but we're talking about ownership. And this notion of, and leaving aside leases for a minute, because the same sort of rules apply to leases, let's come back to a sale. You know, a sale has two parties, a seller and a buyer, right? Seller is selling something, buyer is buying something. Even in a perfect world where no one's going to breach that contract, something else could go wrong. What could go wrong? Between the time that the buyer actually gets the goods from the seller, the goods that the seller is selling could be lost, damaged, stolen, you name it, right? And the question becomes, when does title pass? Because when title passes is when the buyer is obligated to pay for it. And if I'm a buyer, I don't want to pay for anything that I didn't get in mint condition the way I wanted to get it. But could it be possible that under the law, I could be liable? And the answer is yes. And this is why it's so important to understand what the UCC says, what private parties may want to negotiate differently, because you could always change the rules of the UCC, but how could you change them if you don't understand what they mean? And the other important thing that sadly is not on the slides, but I want you to write down in bold letters, well, let me just ask the question. How do you manage risk? How do you manage the risk of being liable for something, having to pay for something when you wouldn't get it? How would a business owner do it? Thank you. Can you please write the word insurance on this slide? You know, it's almost as if they want you to get there without saying it. But I think, you know, again, that's the importance of really studying the stuff, understanding the reading, understanding the slides, and then filling in the information. So yeah, title is legal evidence of ownership. Passage of title to goods, yeah, it cannot pass until the goods are in existence. And how does title pass? Well, title passes based on terms that are agreed to in a contract. Just because you have the Uniform Commercial Code doesn't mean that sellers and buyers don't negotiate. They do, and they should, and they can. And they might just say, if I'm the buyer, I don't want to pay for anything unless I get it in my warehouse, mint condition, delivered. If I'm a seller, I might want to pass that risk on sooner than that, don't I? Right? So already you can see that there is a little bit of a tension there in terms of agreement. But merchant sellers are well aware of this, and a lot of parties negotiate that risk of loss, which is, I mean, look, if you're going to get non-conforming goods, meaning goods that just, someone sloppily slapped together, you can always sue for breach of contract. Right? Here, what you're guarding against is this notion of something getting lost, something getting damaged, something getting stolen, which we know is not a likely event, but it could happen. How, what are you going to do? You may have an excellent insurance policy, in which case you will say, I don't care. I, as a buyer, will say, I'll assume the risk of a shipment contract. We'll see what that means in a minute. As long as you cut me a break on the price. Why wouldn't I, right? I'm already insured for that unlikely event, and let me get a few cents knocked off the price as a result of bowing down on that term, right? But how would I even know that unless I've thought through these issues, right? And that's the important thing, because if no terms are stated, the UCC is going to have its default rules. Title passes when delivery is completed. And we'll see, delivery completed can mean different things. What kind of a delivery is it? Is it a shipment? Is it a destination? Is it a warehouse delivery? What is it? Because at some point, whether the buyer realizes it or not, title has passed. They may not have it in their possession, but if what they're going to get are, water-damaged goods, that's what they're going to get, and they're responsible for it. Unless they have an insurance policy, they're stuck, and they're legally responsible to pay the seller. So let's understand these terminology, these terms, because that's what's going to govern unless you negotiate otherwise. And don't worry, by the time you leave today's shipment and destination contracts, you will be able to recite in your sleep, because we say it so many times, over and over again, that it becomes oh, I get that. I know what a shipment contract is. I know what a destination contract is. So the first time we're saying it, what is a shipment contract? A shipment contract is where the seller makes proper shipping arrangements and delivers the goods into the carrier's hands. What is a carrier? Sure. It could be Maersk. It could be a shipping company. It could be FedEx. It could be DHL. It could be anything. Yeah. And by putting it in their hands, I don't mean literally putting it in their hands. I mean, here's my truckload that I want you to ship. And here we're talking about a seller in California, a buyer in New Jersey, right? It's the only way to get goods from one place to another. What is a destination contract? A destination contract is seller delivering goods either to a buyer's place of business or another specified destination. That doesn't mean that the seller himself has to drive his own truck to get there. All it means is that the risk of loss does not pass from the seller simply because the seller has made shipping arrangements. The seller holds on to that risk, and the seller should have proper insurance, because if something happens, they're going to be left holding the bag because the buyer is not going to pay them for goods that are defective. Right? So don't worry too much. We will come back to shipment and destination a number of times today. All right, what about goods that don't have to move across country? What about goods that could be, I go make a deal with someone in enter into a contract with someone in California, and we enter into a contract. But, you know, today, businesses have distribution centers all over the place, right? And they say, all right, no worries, your goods will be ready for you at our warehouse in Elizabeth. Go pick it up, right? So here, goods don't have to be moved. They are, you know, the seller has operations here in New Jersey. I may have my offices in, let me just pick a fancy address in Short Hills, but I can go to Elizabeth, or my people can go to Elizabeth and go get them. That's not too far of a drive. So in this instance, the buyer is required to pick up the goods from the seller, right? I mean, the distribution center is acting as a conduit of the seller. If the document of title, oh my, or the bill of lading, good God, what is all this terminology coming from, is required, the title passes when the seller delivers the document. So when you read this terminology, did you shake your head and say, what is a bill of lading? What is a document of title? I mean, again, this is nothing more than a seller giving you a barcode receipt or a warehouse receipt and saying, go pick it up. Okay? I mean, where, you know, used to be back in the day, we had to sort of have bills of lading. You know, today proof is electronic. I could go with my smartphone and have something scanned. Okay? That's good enough. So the seller has acknowledged your sale and given you the means by which their facility in Elizabeth will recognize that you have purchased those goods. If no document of title or goods is identified, the title passes at the time of contracting. Okay, fine. But really the rule here is that when does title pass? Title passes when you have the ability, you have been given the way in which you can go pick up the goods. And I want to make sure that this is not in, yeah, it may or may not be in another slide, but I want you to write down here, well, wait a minute. If I get a barcode on my smartphone, does that mean that that's it? I mean, that's it? If I got that in the middle of the night, I have to go pick up the goods now? Otherwise, the risk of loss has passed right away? Of course not. The UCC is reasonable and says basically the buyer has a reasonable period of time from when they get the document of title, when we're talking about goods that don't have to be moved, to go pick them up. What's reasonable? I know you're looking for a bright line answer. I don't have one. It depends, right? It's not 6 months from now, you know, but when we're talking about, you know, goods that I have to get a truck for, you know, it could take me a week, a few days or so. Risk of loss will not pass. You know, what if there's a fire at that facility in Elizabeth and it took me 2 days to go get it? Risk of loss didn't pass yet. It wasn't a reasonable time that I had to arrange to go pick it up. Okay, so again, and we'll keep coming back to these concepts about, because what this chapter is all about is managing risk and when does it pass. Again, we're talking about the exact same thing, and I promise you we're about to take a break. Carrier cases, right? Carrier cases mean that the goods have to be moved, right? This is review. It's just putting it all together. When you have a carrier case, you either have a shipment contract or a destination contract. The shipment contract says that risk of loss passes to buyer when the seller delivers conforming goods. What does that mean? I hate it when I see a word I don't recognize, right? Conforming goods. Anyone? Yeah, I'll give it to you. It's goods that I negotiated. It's goods that I contracted for. It's what I wanted. Okay? Yes, risk of loss passes to buyer when seller delivers the goods that were contracted for under the contract to the carrier. All right? By now, here, I always say the buyer is on the hook now, starting now. Either the buyer has rolled the die and basically is taking the chance that it's very unlikely that something will happen, or they have proper insurance to protect them from this time forward. Destination contract. Sorry if it's cutting off. Risk of loss passes to buyer when seller delivers the conforming goods to the specified destination. So here, the risk of loss will not pass until for example, the buyer, if I have my business in Short Hills, New Jersey, until someone knocks on my door and makes a delivery. Here, who's on the hook until that time? The seller. So the seller basically has to have, because again, something could go wrong, right? You know, you could have a storm. You know, the package could be left outside for a while and it could be all soaked. Those 100 dresses that I wanted for Valentine's Day are ruined, right? So again, it's a way of managing liability. So when people enter into a contract and it says delivery term shipment contract, understand what that means. Don't like it? Negotiate. Otherwise, UCC defines what a shipment contract is and what a destination contract is, what it means, and when risk of loss passes. And just bear with me. And this is the last concept we'll cover before the break. What if it's a non-carrier case, meaning there is no movement of goods, meaning that it's, you know, a garage, a warehouse somewhere that you're picking it up from. Or it could also be that you go to the seller's place of business, right? I'm a buyer, I'm going there, and you're going to give it to me, right? Here, we're back to talking about the difference between a merchant and a non-merchant, because the rule is a little bit different. All right, so if I'm a seller and a buyer is coming to me to purchase something, and it doesn't matter whether the buyer is a merchant or a non-merchant. Okay, this is a rule that only applies to merchant sellers. So let's say I am Costco, all right, you know, and I'm selling stuff. There's no question that Costco is a merchant, right? And you know, a business owner comes in, they buy a ton of stuff, right? Businesses buy a lot of stuff from Costco, good prices, and so on and so forth. And they buy, I don't know, office equipment right there at Costco. And if you've I guess everyone hopefully has been to a Costco, you know, delivery. They say, oh, go on the side of the garage, back up your truck, you know, we'll have this equipment for you, right? When does the risk of loss pass? Well, we say, what's going to happen? Well, things can happen, right? You could have a crazy person drive into your delivery as they're backing up. Anything can happen, right? So the question is, when does risk of loss pass? Risk of loss passes to buyer when the buyer receives the goods. So a merchant seller is being held to a high standard. So I paid for it. They told me to go pick it up. I decided to go get an ice cream cone or do something else in the meantime. And by the time that my stuff is sitting out there, some crazy person in the parking lot rams right into my delivery, and it's ruined, right? Who bears the risk of loss there? Well, it was a non-carrier case. The thing was, I was dealing with a merchant seller. Whew. As a buyer, I'm protected, and as Costco, I will still be okay because I'm insured against those types of risk. I have managed that liability. I know about it. What if we're talking about a non-merchant seller? What if I'm buying from someone who's a casual seller? When does risk of loss pass there? Well, risk of loss, unless I negotiate otherwise, passes to buyer upon tender of delivery. And you might say, what does that mean? Tender of delivery essentially means when the buyer is free and clear to take it. Okay? So, I don't know, think yard sales. Yeah, pay the money and you know, it's over. The sale is consummated. So anyone been to a yard sale? Come on, we all have, right? We won't admit it, but we have. And you know, you see something, and let me just sort of paint a picture. I see a vintage chair, and I say that's going to look great in my store out in Short Hills, in my reception area, right? Doesn't matter if I'm a merchant buyer or not a merchant buyer. What we're looking is we have a non-merchant seller. We've got some person just taking out their stuff and putting it on their yard and selling the stuff. I say, I want that lime green lawn, did I say lawn chair? No, let's make it a reception chair or something. And I love it, and I gave $200, $500, whatever they were charging, and I think I have a great deal. But the only problem is that I was just strolling. I didn't bring the right car. I want to go back, and I want to get my truck so I can take it. And I say, hold on to that chair. I'll be back in a half an hour. Within a half an hour, the skies part, rain comes, the seller is busy doing their own thing, they don't notice my chair is ruined. And let's even say that's not ruined. Let's say it was just a few spotty showers, but it just has a little spot on it. I don't want it anymore. I mean, it's going to cost me more to get this cleaned up. I said, give me my money back. This is faulty. Now, maybe that a nice person may give their money back, but let's look at the black letter of the law. The black letter of the law says when I'm dealing with a non-merchant seller, risk of loss has passed upon tender of delivery. There had been tender of delivery a half hour ago. The seller, in this case, was not unreasonable. They were doing their own stuff. They didn't really pay attention to a passing rain shower and the fact that there was now a little spot on your chair. Too bad. Risk of loss passing. You might say, well, who insures against those losses? Look, I could given you a very different example of buying something of more value. The point is, know when risk of loss passes in these kinds of scenarios. And when you've got a non-carrier case, it does matter whether or not you bought from a merchant seller or whether or not you bought from a non-merchant seller. All right, I see yawns. I see eyes glazing. I think it is time to take a quick break. Yes? Yeah. Right. So the question, okay, we will do our best to get through this material and give it the respect that it deserves and the time that it deserves before most of you have to leave for your next scheduled 12:30 class. All right? So bear with me. We're going to make this happen. All right, ready? All right, so we left off, I love enthusiasm, we left off with when does risk of loss pass, and I guess I didn't stress enough when there is no breach of a contract, right? Because if there's a breach, it's a different story, and everyone remember what a breach is, right? When one party doesn't do what they were supposed to do. So assuming that the seller does what the seller said they were going to do, the buyer is going to do what the buyer said they were going to do, the fact is that something happens during delivery. That's the issue, right? So far we've talked about shipment and destination when we're talking about a carrier case. And the last slide we covered was this difference between merchant and non-merchant sellers when we're talking about goods being in the possession of a seller. And the third instance is when you have goods that are being held by a bailee. Now, no one here has not taken Business Law 1, right? So everyone knows what a bailment is, right? Right. What is a bailment? You had your hand up, Julian, and you took it down. Yeah, that's one type of a bailment. I mean, a bailment is when some intermediary party has legal possession of the goods, even though they don't own them. But they have it for some lawful purpose. And here, when we're talking about bailees under UCC Article 2 or 2A, you might as well cross that word and say warehouse. Because typically, that's what we're talking about. Goods in the warehouse somewhere. And a bailee is a type of a warehouse, right? So, here you have a transaction between the seller or buyer where the buyer is supposed to go and pick up the goods within a reasonable period of time from some warehouse. And if you remember before the break, I gave the example of my business in Short Hills where I made a contract with a seller in California, and the seller in California told me to go get my goods from their warehouse, from the bailee in Elizabeth, right? So that's kind of the situation. So when does risk of loss pass there? Well, the buyer receives negotiable document of title, or the bailee acknowledges buyer's right to possession, and all that means is that I have the receipt or I have the barcode, I have something that shows that I have paid for these goods and I can take them from the warehouse, okay? Once that happens and the buyer receives a negotiable document of title and has reasonable time to demand those goods. So again, look at the reasonable time here, right? So from the time that I have the legal authority to go pick up the goods to a reasonable time thereafter, I'm going to get sort of lost my train of thought. I'm going to be responsible for the risk of loss. And again, I come back to what is a reasonable time? Well, it depends. What are the kinds of goods I'm picking up? How long has it been? How long have I been in possession of my negotiable document of title, and so on and so forth, right? So it's within a reasonable period of time. Again, months and months after, not reasonable. A few days after, totally reasonable. Maybe in some instances, even a week or two, if it takes time for me to coordinate picking up that delivery, right? Until that time, if something happens at that warehouse, the seller is responsible. And someone said to me, well, what if it's during the break, someone came up to me and said, well, what if it's a carrier's fault? What if it's a fault of the warehouse? They left, if someone was smoking or something, and they set the warehouse on fire. That's not the seller's fault, right? Why should they be holding the bag? Listen, here we're talking about a sales contract between a buyer and a seller. Yes, an intermediary might have done something wrong, but between the parties to the contract, the seller is still responsible. And to the extent that their warehouse did something wrong, they can sue the warehouse later on. But the fact of the matter is, the buyer is not going to be responsible, doesn't have the risk of loss until at least a reasonable time after they've been notified that they can go pick up the goods. Okay? Now, a couple of easy slides. Everything that we've talked about so far dealt with when everyone, the seller, the buyer, had done nothing wrong, and it really was something that happened during delivery, right, that went wrong. And that's what we're talking about. When does the risk of loss pass? But what happens if the seller was in breach of contract, meaning they shipped the goods late, they shipped faulty goods, meaning they shipped non-conforming goods and so on? The UCC has a bright line rule, and the bright line rule is easy. If the seller is in breach of a sales contract, the seller, they could call it a shipment contract if they want to, is still going to retain the risk of goods. Why? Risk of loss rather. Why? Because any time that you put non-conforming goods off on shipment, you have never passed the risk of loss. So in order for the risk of loss to pass to a buyer under a shipment contract, the seller has to do everything right, right? Breach of contract, risk of loss never passes. It remains with the seller until they fix it. That's what it means to cure the nonconformity. Or the buyer says, doesn't matter, I'll accept it anyway, right? So you can always negotiate a different rule. However, the UCC simply says, under a bright line rule, risk of loss will never pass from a seller to a buyer if the seller is in breach of contract when it ships the goods. And the flip side of that rule applies as well. If the buyer is in breach of contract, meaning, and how can a buyer breach a contract? Well, the buyer is not sending the goods, but the buyer could refuse to take delivery of goods that they negotiated and contracted for. They could repudiate, meaning cancel the contract without just cause, or in some other way breach the contract, meaning not pay for it, or whatever the case might be. If the buyer does something wrong, then even if this was a destination contract, meaning the risk of loss wouldn't have passed until it came to their doorstep, it is possible that the risk of loss could pass earlier. Okay? So all you have to remember is a general rule that says that risk of loss will never pass from the party that is in breach of contract. I pause to make sure that everyone understands. And I move on. We change gears a little bit, okay? We, for the moment, are done with risk of loss. We'll come back to it in a few minutes in the next chapter. Now we're going to talk about 2 or 3 different types of sales. And these are called conditional sales, right? And again, when you think about words, think about their meaning. Conditional, condition. When you put a condition on something, right? That's what we're getting at. The first type of conditional sale is something under the UCC called a sale on approval. A sale on approval. And here the UCC says that there isn't even a sale meaning no risk of loss is passing, unless and until the buyer accepts the goods. So very few sellers will make a sale on approval, because this is where, take the merchandise, take it, it's yours, buyer, and you don't have to pay for it unless you approve in 10 days, right? If I'm a seller, I don't want that, right? I'm really allowing somebody to take a long time where I'm holding on to the fact that it could get damaged, it could get whatever. You know, I'm not even making a sale because they could change their mind, right? But if I'm the type of seller that it sells perhaps very high-end items or items that I really want to unload and there is no market for them, I have no choice but to give buyers that kind of autonomy, then I may not have a choice. So these kinds of sales are not that common, but they do happen. What we need to remember here is that the risk of loss and title are only passed when goods are accepted by the buyer. And the buyer that has 10 days to look at the book, to look at whatever, and say, I don't want it, or I do want it, you know, whatever the case might be. If it's day 7, they haven't made up their mind, right? If something happens to those goods, even though they were with the buyer, the seller bears the risk of loss and had better have planned for it, okay? That's a sale on approval, where the buyer is very much in the driver's seat. Yes? Can you bear with me, because you haven't accepted it, you just start to open up the boxes. Bear with me. Next chapter, I promise. And if I don't do it, you can call me out, but I'm confident I will. Okay. Conditional sale. So that's sale on approval. Now look at the terminology. Sale or return. Sale or return. This is the kind of transaction which most of us enter into, right? Buyer may return goods. And by the way, these goods could be totally fine. There's no breach. They're not non-conforming. Buyer has a right to change their mind. And you know, that happens sometimes. Even as a consumer, we go to a department store. We see something. We impulse buy it. We come home. There's nothing wrong with it. Reality sets in, and we march ourselves down in shame, get into that return line and say, I want to return it. And they ask, is there something wrong with it? And we say, no. Just decided I don't want it anymore, right? Whatever. That is a type of a sale or return. Now, take that and put that in the larger commercial sense, right? You know, a buyer could return goods after a period of time, right? They have the right to do that. But the difference here is that the risk of loss and title passes to the buyer when the buyer takes possession. So just because you have the right under the contract to return the goods within a period of time doesn't mean that risk of loss hasn't passed. So if something happens while in the buyer's possession, of course the buyer is liable. This is not the same as sale on approval. The third type of conditional sale is something that maybe most of us are kind of familiar with. A consignment sale. Everyone knows what a consignment is? If you don't, I'll explain. Someone give me an example of a consignment. Has anyone ever been involved? There you go. Right. Well, why don't you just sell your own diamond jewelry? Right. Right, exactly right. I'm just challenging you on purpose, but right. The whole point of a consignment is that someone has something to sell. They don't have a storefront to sell it from, right? So they go to the appropriate place. They will try to sell it for them for whatever price that they've decided is a minimum price or whatever, but they get a cut of that, right? That's what it is, sure. So here we've got a seller. That's you with your diamond ring. You're the consignor. You give your goods to a buyer, the consignee, that's a jewelry shop, to sell to someone else, to sell to a consumer. The consignee, the jewelry store, is paid a fee for selling the goods on behalf of the consignor. I'd be happy to get $20,000 for this diamond ring. I wish I had a $20,000 diamond ring, because I would, I'm happy to pay the jewelry shop, a percentage. Even 10% would be, nominal, considering the fact that I could get, someone to pay top dollar for the diamond ring. The question is, what happens if that diamond ring is damaged through no fault of the jewelry store? The jewelry store catches on fire. There's a theft or something like that happens. Who bears the risk? Unless the parties negotiate otherwise, the law treats consignment sales as a sale or return. What does that mean then? I'm testing you. If it's a sale or return, something we covered in the previous slide, the buyer. And who is the buyer? The jewelry store, also known as the consignee. Does everyone understand how terminology can be tricky? But the concept is not all that confusing. I mean, if the jewelry store, they better add their consigned items to their insurance policy, because they are liable for damages that happen while those items are in their possession. Mm-hmm.
And those guys were not insured, the liability falls on the store owner.
Right, but good luck collecting on that. I mean, it's a good question. I don't know if you sort of heard it. It's a practical question, because the question is, let's say it's a jewelry shop in Newark. Someone left something there to sell. Unfortunately, the jewelry shop doesn't even have the requisite amount of insurance. It got broken into. Who do you, as a consignor, have the ability to go after, assuming you can't find the thief, right? Which usually is the case. The answer is, yes, you could go after the owner, but the practical problem is, will there be any funds to pay you out, right? It all depends on, the owner's resources, and that's a practical problem. Okay, with leases, what happens? I sort of say the leases are the stepchild here, right? But we remember Article 2A is leases. In an ordinary lease, meaning not a finance lease, meaning where there is no third party that is financing it, risk of loss is typically retained by the lessor. Who's the lessor? The person who has title. If you want to negotiate it, and most lessors would, they could negotiate it where the lessee assumes a liability, but the UCC default rule is it's a lessor. If it's a finance lease, believe me, no bank wants to hold that liability. They're passing it on to the lessee. So this goes back to people that sort of ask questions about their leased cars and so on. You have the risk of loss as the lessee. And again, the same rule, if the goods that are leased are non-conforming, the risk of loss never passes, because it's the same rule as sale of goods. If the lessor didn't give you what they said they were going to give you, the risk of loss will not pass until they correct that breach of contract. Now, we get to talk about the bad guys. Yes, sorry. Finance lease. No, it can never be an apartment, because it would be real estate. It would be office equipment. It could be a sofa. It could be a television set that you rent. It could be anything that is goods. Under the UCC rule, which could be changed, but the UCC says that the store that leased you the equipment holds on to the risk of loss. But believe me, in the real world, they're looking to pass that on to the lessee. It's called a finance lease, and practically speaking, it'll always be borne by the lessee. Julian, you had a question? Oh, it could be. I mean, other things could be a finance lease. The car just came to mind as an easy example. You could have equipment be a finance lease too, right? But to the extent that it's not a finance lease, the default rule is that the risk of loss is with the lessor. If it is a finance lease, then the risk of loss is with the lessee. Yes? They say we finance, but they're usually working with some kind of a company that works through them. Be careful of those fast-talking car salesmen, you know. But oftentimes, I mean, they're affiliated, and it could be that it's a subsidiary of their company. Yeah. All right. So now let's talk about, you know, so far we've talked about buyers and sellers that have all acted in good faith and have legitimate title to, for example, a seller has title, legal title, meaning lawful title to what they're selling. But let's come into the real world. It is possible, heaven forbid, that someone actually breaks the law. And person who is selling you something stole it, got it through fraudulent means, whatever the case might be, and they're selling you something that is hot. You don't know it. Who's liable? Right? That's what we're talking about here. This is sale of goods by non-owners. So there's something called void title, which is a situation in which a thief steals something. So someone who, I shouldn't have to, you know, this is sort of an obvious thing. If you steal something, you don't get valid title. You don't get valid ownership. It's a criminal law issue, and it's a contract law issue as well. But what that also means, unfortunately, is the buyer who buys from a thief cannot get good title because the person giving them the title didn't have good title. And same thing, a lessee cannot get good title to lease goods. So, but a lot of people say, but what, I didn't know. It looked like, I mean, how could I know? Why am I, when it comes to being a good buyer, held to such a high standard when everything about the sale to me looked like on the up and up? And this is where I say the law has to draw a bright line rule somewhere. And the bright line rule is that no matter how conscientious a buyer you were, you cannot, under the eyes of the law, get good title when you buy something from the back of a truck, because presumably those items could be hot, right? And what that means is if there's a way that they can trace those goods to you, they meaning the authorities, they have the lawful right to take them, and your only recourse is to go sue the person you bought it from, who was a thief. So that's never going to go well. So the point of the slide is you cannot get good title from a thief. Okay. Now it starts to get a little bit murkier. What if the person that you bought from was not an outright thief, but they were still a bad guy? Because, or bad gal, I shouldn't be chauvinistic in my language. They actually got the goods through fraud. A white-collar fraud, but a fraud nonetheless. So here the seller has voidable title to goods that were obtained. For example, they're selling things in their store, but they wrote a bum check to get it, right? You go into that store and you buy something. How do you know that they wrote a bum check to get it? What are the rules there? You know what? The slide doesn't tell you that. Let me tell you what the rule is, because the book tells you what the rule is. Depends on who you are. If you are write this down, a GFP, a good faith purchaser for value, a GFP, a good faith purchaser, and you pay value, you may be protected. And you may say, well, what does that mean? Well, what it means is that you're a good faith purchaser, meaning you have no knowledge in this instance of there being an underlying fraud involved. And you paid good value, meaning there were no sirens that should have been going off in your head that you were getting too good a deal. You went to a store and you bought a Rolex watch. I don't know what Rolex watches go for, but they go for a few thousand. And someone was willing to sell it to you for $500. Query whether to a reasonable person that shouldn't have been sending off signals that something may not be right here, right? Because if you're not a good faith purchaser for value, those goods can be taken from you because you're not someone that got legitimate ownership, legitimate title. But this law is supposed to protect people that at least didn't buy from a thief, but bought from someone who was perpetrating a fraud, so long as they didn't know anything about the fraud and they paid reasonable value for it. Everyone with me? Now, the last category, oh, purchaser for value was there. I apologize. Okay. Sometimes I'm better than I think I am. All right. Now, this rule, just about everyone hates the outcome of this rule because it seems so unfair. And I can already see people shaking their heads. It seems unfair, but it's about the best rule in a bad situation. And this is called the entrustment rule. If the owner of goods entrusts the possession of his or her goods to a merchant, back to talking about a merchant only, who deals in goods of that kind, bear with me, I'll translate it into English in a minute, the merchant has the power to transfer all rights in the goods to a buyer in the ordinary course of business. The real owner cannot reclaim the goods from this buyer. Oh my God. Okay. So this is, let me paint a picture. Let's go back to a jewelry store. But this time I took my ring there not to sell, but to get cleaned, to get polished. Okay? And it is my grandmother's ring, about the most precious thing I own. Not because of its worth, but because of its sentimental value. All right, you can see I'm setting it up for a heartbreak kind of a case. I go to my local jewelry store, and they are very conscientious. They're very, very nice. They take it, but they have a new staff member, and they didn't properly communicate to that staff member what it is that they were supposed to do with this ring. So someone does polish it up and makes it look beautiful. But the thing about this jewelry store is they sell both new items and antique items. And what they do after doing it is they put it in the display case. Someone comes along in the ordinary course of business, looks at this ring and says, my God, I haven't seen anything like that in decades. It's beautiful. They see it, they negotiate a price, they buy it. You come back, I come back, 3 days later, and they are beside themselves. They have sold it. They try to contact the owner who bought it, and that owner refuses to sell it back. Guess what? I, as the real owner, have no legal recourse. No legal recourse to get the ring back. That doesn't mean I don't have legal recourse against a jewelry store to get the value of that ring. But here's the problem. I just explained to you the value of that ring to me was far more than a few $1,000s. You cannot put a value of sentimental, a one-of-a-kind sort of thing. But guess what? I can't do anything because of the entrustment rule, except to beg the person who essentially bought it to, but they're under no legal liability to have to return it to me. Why? What happened here was a mistake. But there's just nothing you can do to change it. That is the entrustment rule. Does everyone hate it? But do people kind of see the logic behind it? Because you have to say, well, why should someone in the ordinary course of business pay for the mistake of the jewelry store when they didn't know any better? And now, let me sort of switch this around a little bit, and we have a case here that kind of ends this chapter on entrustment rule. You don't have to give me all the sordid facts, but I think it's possible to describe this case in a few words. What happened in this Supreme Court of Connecticut case from 2007? It's not that dated. Yes?
Someone sold
A painting.
or entrusted the person or a merchant to just show it on a museum.
Exactly. So someone owned a one-of-a-kind Van Gogh, or Andy Warhol in this case, whatever it was. It was more contemporary than that. Thank you. Yeah, a rich art collector gave, I think it's to the Museum of Modern Art or one of these, museums in New York City. Well, what he did was this art collector had an agent, and the agent negotiated, and a lot of people do that. They will give it to a museum to display for a period of time, and the museum was displaying. Okay, and then I'll let you finish. Well, it kind of something for, yeah, we have to say who the he is. So what happened here was the agent says to the art collector, oh, now that the showing is over in New York City, the museum in Denmark would like to have a showing of this piece. And the art collector says, oh, okay, why don't we send it on? That's fine. So he entrusts the painting to the agent. The agent had no plans of sending it to Denmark. He made up the lie. He was a crook. And he winds up selling it to someone else for like $2-point-some million. Okay? And in the meantime, the real owner gets an offer to buy this painting for nearly $5 million from some Japanese art collector. And he says to the agent, can I have my painting back? I just sold it. Well, at this point, I think he sort of wises up to the fact the agent has probably skipped town. There is no painting to be had, and he finds out that someone named Brandt owns this painting for $2.9 million, and they are refusing to give it back. And he sues. He sues Brandt directly. And the question is Brandt a buyer in the ordinary course of business who has a claim of ownership to Red Elvis, the painting by Andy Warhol, that is superior to the claim of the real owner? I'm hearing no's and yeses. Somebody defend. Who wants to defend the no? Owner. He lied. I've got a newsflash. Crooks lie. Right. But on the other hand, think, when art collectors have agents, one of the things they do is they negotiate to have this piece viewed in museums, and one of the reasons they do that is because they want to sell it, ultimately. And two is that they negotiate sales on behalf of their principal. Right? Yes? It could, and you could argue that, but here, the notion that, remember, a piece of art is so subjective. $2.9 million is nothing to laugh at. The fact that he got a higher bidder doesn't mean that it was so undervalued, but I see your point. One could argue that he was not a good faith purchaser for value, but in this case, the court says no. We're going to say that he was a good faith purchaser for value, and in fact, we're going to say he was a buyer in the ordinary course of business, because one of the things agents do for their principal art dealers is that they sell paintings, they put them up for viewing, so there was nothing to put Brandt on notice. And here, Brandt gets to keep it. And what happens, fortunately or unfortunately, is that this guy now sues his agent. And he gets a $5-point-something million judgment. What's the problem with that? Exactly. It's a judgment on paper. You got a judgment against a crook. Bravo, it may be a moral victory. I don't know how you translate that into real dollars and cents. So it is an unfortunate case. I would say the jewelry store is a better deep pocket to go after. Going after a crook here left the guy, unfortunately, empty-handed in this case. So, a case that doesn't have an equitable result, but then what do you do in a case like this? If you take it away from Brandt, why should he be out $2.9 million, right? So there is no good solution to when you have a bad party involved.